Bail is the rule and jail an exception principle shall also apply to cases registered under the Unlawful Activities Prevention Act or UAPA, the anti-terror law that has stringent bail conditions, the Supreme Court has held on Tuesday. In a significant verdict that is likely to have a bearing on UAPA cases where accused are languishing in jail for long, the top court reminded high courts and trial courts about the settled law on bail and told them that they should not hesitate to grant it when a case was made out for one, even when anti-terror charges are invoked. Denying bail in deserving cases will violate the right to life guaranteed under Article 21, which encompasses the right to live with dignity. The top court issued this diktat in a bail order granted to a man from Bihar who was arrested in 2022 for his alleged association with the Popular Front of India or PFI. One of the charges levelled against him was that he and his co-accused had conspired to carry out a terror attack during the visit of Prime Minister Narendra Modi in May 2022. Now, why is this ruling important and what are its implications? I will tell you more about this in this video. But before that, let me take you through to the law that we are talking about. The Unlawful Activities Prevention Act or UAPA is a special legislation that is meant for effective prevention of certain unlawful activities of individuals and associations and for dealing with terrorist activities. Due to a certain provision in it, UAPA is often described as a draconian law. This provision is related to bail jurisprudence and makes it tough for those arrested under it to get released on bail. Therefore, while in regular criminal cases, bail is supposed to be the norm and pre-trial jail the exception, it is not so in UAPA matters. This is section 43D subsection 5 of the UAPA, which says that a person accused of an offence under chapters 4 and 6 that relate to terrorism and belonging to a terrorist organisation shall not be released on bail if the court, after perusing the case diary and police report, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. This is a departure from ordinary criminal cases where the prosecution has to establish that the accused seeking bail is either a flight risk, holds an influential position that can be misused to tamper with evidence, or is capable of influencing or threatening witnesses. Due to this provision, a hearing for regular bail in UAPA cases is akin to a mini trial where courts have to weigh in the prosecution evidence to form a prima facie opinion either against or favouring the accused. So, what is the implication of section 43D5? This provision actually adds an extra layer of scrutiny in bail hearings, making the application of bail as rule and jail an exception principle difficult in anti-terror cases. The law reverses the obligation of the burden of proof, putting the onus on the accused to prove that they are not prima facie guilty even for getting bail. A Supreme Court judgment in April 2019 further increased the challenges for UAPA undertrials to get bail. Called the Zahoor Ahmad Shah Watali judgment, this ruling held that at the stage of bail, the court wasn't required to weigh the evidence against an accused and that it was only supposed to look at the material provided by the investigation in its entirety to see if there was a prima facie case. It's a combination of stringent UAPA bail provisions and this 2019 Supreme Court judgment that is keeping many accused arrested under this law in jail. However, Tuesday's judgment by Justice Oka's bench reinforces the stand the top court has taken in a slew of recent verdicts in UAPA cases where it has acknowledged the importance of personal liberty while granting bail in matters. In May this year, a bench led by Justice B.R. Gavai had quashed the arrest of NewsClick owner Prabir Purkaista while observing that his arrest did not comply with the legal procedure in UAPA. Later in July, a bench headed by Justice J.B. Pardiwala granted bail to a man arrested on terror charges after noting that the trial in his case was proceeding at a snail's pace. Prolonged incarceration and delay in trial are good grounds to grant bail, the bench had said in that case. Justice Oak's judgment comes days after the Supreme Court, while granting bail to former Deputy Chief Minister of Delhi, Manish Sisodia, underlined that the right to a speedy trial should be read into Section 45 of the Prevention of Money Laundering Act, another special legislation that has stringent provisions like the UAPA, seen as barriers in the granting of bail to those arrested under two laws. The case in which Justice Oka's bench delivered the verdict was filed by the National Intelligence Agency against one Jalaluddin Khan. Arrested in July 2022, Khan was charged with conspiring with PFI members to carry out terror attacks. His association with PFI had been established by Khan giving his house on rent to the organization and its members, the NIA had alleged. Khan was arrested alongside another PFI member. In support of its allegations, NIA referenced statements recorded by protected witnesses. The agency filed an affidavit claiming that one of the witnesses had alleged Khan took part in a meeting with PFI members to discuss its future plans. The court, however, said, and I quote, "Even in a case like the present case, which is under UPA, where there are stringent conditions for grant of bail in the relevant statutes, the same rule holds good, with only modification that the bail can be granted if the conditions in the statute are satisfied." The court ordered Khan's release with a prima facie finding that no terrorist charges could be made against him as of now. In a categorical statement, the court said that the bail is a rule and jail an exception principle means that once a case is made out for the grant of bail, the court cannot decline it. On perusing the charge sheet and statement of a protected witness, the top court opined the allegations against Khan lacked merits. The bench took exception to NIA attributing statements to this witness that were not made by him and asked the agency to submit an explanation on this account and termed the NIA's affidavit as unfortunate. The bench also held that the circumstances based on which the NIA had booked Khan prima facie did not disclose his alleged involvement in the case. Assuming Khan knew the co-accused was associated with PFI, the court said the mere association was not an offence since the organization was not a banned one at that time. Also, the charge sheet filed in the case did not show any connection between Khan and PFI. The charge sheet also did not mention any specific material that showed that Khan had advocated, abetted, or incited anyone to take part in a terror attack. Releasing Khan on bail, the bench directed him to appear before a special NIA court within a maximum period of 7 days from Tuesday, ordering that the trial court would allow Khan to be out on bail until the conclusion of the trial under terms and conditions decided after hearing both sides.